in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
Ms. Dineski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no for service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
Okay, Miss.
We had a trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing, and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're arraigning it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interest in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights.
Buckle up, guys. Today we're diving headfirst into legal chaos of Lindsay Dineski, who storms into court already on fire, before the judge can even finish swearing her in. She accuses the system of lies and demands dismissal. It's the sovereign citizen energy you never knew you needed. If you thought this would be a calm courtroom proceeding, think again. This is just the beginning, and Lindsay is already derailing everything in sight.
And Article 1 judges.
So the court is in receipt of a customer information form that appears.
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Stand by.
Yeah, stand by. This is also a bill of payment penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping. and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have.
All right, guys, here's where things start going completely off the rails. Lindsay begins questioning the judge's authority, asking if it's an Article 1 or Article 3 court, and tries to toss in presidential executive orders as legal proof. She claims her children are her liberty interests and declares the entire case void. The judge tries to keep things on track, but Lindsay just keeps pushing, louder and wilder. She's not here for justice. She's here for chaos.
Or bear arms.
Is like
Ms. Danelski, I'm gonna put you in the breakout room with Ms.
This is a violation of my Fifth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Okay, we don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And I need
Deputy,
to
did you hear me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in judgment.
I don't need an attorney. I don't consent to an
Yeah,
attorney.
I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Miss Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was
I got
not even
you.
notified of this court. I was not even given notice of this court date, and I've been here for
So
5 days.
Mr. Ness, please
let's
be
say
quiet.
1:45. I don't have a
You
prosecutor.
don't need to
I
be
can't
quiet.
do
This
anything.
is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay,
All right,
I'll
we'll
be
see y'all
back at
back at
1:45.
1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm
we
waiting
looking
on a
at
prosecutor.
2:30?
I can't.
Well, it has
The
to go,
record is
Your Honor,
going
I have
now.
a 2:00.
I can't
I
call it.
don't
So
need a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
You just ignore my.
And now the courtroom turns into a full-blown constitutional meltdown. Lindsay accuses a judge of crimes and demands a death penalty under U.S. Code. That's right. She actually cites federal law and threatens capital punishment on court officials. The meltdown is so outrageous, even the commentator cuts in with disbelief. Lindsay isn't arguing her case. She's fighting a personal war against reality, one legal buzzword at a time.
I do believe arraignments can take place without the prosecutor's office, but
I kind of thought
Must be
so. I
big.
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
I've been, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-born arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you. Unmute.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Daneski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of Mr.
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Daneski in the breakout room.
So why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And
Certainly.
I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Zaneski, you were arrested for a
For
warrant,
what?
for a warrant issued because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6.
Welcome to Lindsay's solo show. With the judge gone, she starts ranting into the void, citing everything from treason to torture to Marbury versus Madison. She drops constitutional clauses like confetti and accuses the court of kidnapping, all while completely alone in a breakout room. It's courtroom theater at its weirdest. And somehow, Lindsay still thinks she's winning. This is sovereign citizen karaoke at its absolute peak.
2, 3, not personally notified. I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation,
6.
which 2.516.
No,
does
I'm sorry,
rule of
2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a
does
civil procedure because it's family court.
Hold on, Ms. Daneski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Daneski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
All right, go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for
Right.
this proceeding.
You may
Is
proceed.
applicable or, I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead,
Your
Mr.
Honor, I must correct the court. The argument is not applicable, inapplicable.
Back in court, the judge tries to pause the hearing, but Lindsay's not having it. She demands to proceed despite no prosecutor being present, screams that she wasn't notified, and throws in a bizarre Cold War reference for good measure. The judge schedules a break, but Lindsay won't stop yelling. When things calm down just enough, she drops one more bomb. Why do you ignore my questions? Simple, because they make no sense.
Not applicable.
Why would it be inapplicable?
He's saying
This
your
is-
court rule. He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi-criminal matters.
This is not a criminal matter. This is a civil matter.
Which
It's
is
a
why you're in
domestic,
jail.
it's a domestic matter. How is that criminal?
Ms. Daneski.
And in criminal procedure, it's the same thing. These also, the criminal code
Ms.
also.
Daneski,
The
you
reason
have to.
why, ma'am, the reason why I looked up the.
I'll
civil
give you
code
an
is because it's a
opportunity to
civil-
speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first. This is
No.
my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not
I'm
notified
sorry,
of
the
anything.
allegation that you violated a PPO.
Okay, well, then I have a right to say was not
I'm going
notified.
to give you that opportunity, but you have to, the allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court informed the respondent of the standards for which respondent will be held if proceeding pro se. And I believe it would be appropriate to.
I'm proceeding sui juris and
Well,
persona.
I am going to ask Ms. Fort Williams to operate as.
No, I don't want an attorney. I do
And
not
my
consent to an attorney.
Ms. Janeski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
Here we go again, now with a full courtroom, prosecutor included. Lindsay refuses counsel, insists on defending herself, and immediately starts interrupting every official. She misquotes legal codes, demands dismissals mid-arraignment, and argues that prosecutors have no place in family court. The judge tries to educate her, but she's on another planet entirely. Lindsay's not in a courtroom. She's in her own legal fantasy realm.
Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you
Your
understand? Go ahead, Ms.
Honor.
Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Your Honor, Mr. Nesky, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arraignment.
Miss. Procedurally, there are things we have to do, Mr.
No, not if my rights are violated.
The final showdown. The court enters a not guilty plea on Lindsay's behalf, and she erupts again, accusing petitioner of fraud and demanding the whole case be thrown out. The judge stays composed while she continues shouting, still insisting on self-representation. The prosecutor calmly explains the law, but Lindsay is too deep in denial to listen. And just like that, the hearing wraps. If you enjoyed this courtroom roller coaster, make sure to like the video, subscribe to the channel, and we'll see you in the next one.